Advance Drive. I didn't prepare a speech. I just wanted to basically thank you guys for the meetings in May and June. And I am hoping that those two big issues, the electric compressors and the air and water monitoring, will still stand. I always think about it in terms of my profession, especially with the air and water testing. As a teacher, I have walkthroughs constantly, unannounced by my principals, my superintendent, my assistant superintendent. And if I'm doing my job correctly, if I am teaching to the best of my ability, my children are active and learning, then there is no reason for me to be concerned. It's the teachers that aren't doing their jobs correctly, those are the ones that should be worried. And the fact that that condition is, Mark West wants to drop that condition, concerns me. Because in my personal opinion, if there's nothing to hide, then there should not be an issue in that condition, period. I am also part of the interveners, so please know that you do have our backing. It's not just you two parties, it is all four of us, and we are here to support you.
The audience. So if I have one question. Mr. Kamen and Mr. White both expressed that the board is not taking, you should understand, no action taken tonight.
And I think that is an option you can do. If you want to take no action tonight, that would be an option.
I mean, I understand their position. Is that a legal position? I mean, are they correct?
I believe their position, if I understand it correctly, is they intervened in the Washington County action, taking party status as of a right. The way
I
code reads is
they think the board should act, and we have a problem. Is that correct?
I think no matter. I think if this would be approved tonight, I'm sure, based on the testimony, based on the statements of counsel, that this will end up in court.
Mr. Kamen?
Yes.
You believe it's illegal for the board to take any action tonight?
I do. Mr. Augustine, I disagree. Mr. White also has that opinion, correct, Mr. White?
I do.
I disagree. The suggestion that a party to litigation cannot take action, which you must do publicly here, which is why you're here this evening, take that action in public. The suggestion that you are somehow hamstrung because we took an appeal to the Court of Common Pleas. It's the Court of Common Pleas that will enter any stipulation in order here. You have the ability to act as a board, which is what you're doing here this evening in public as required by the Sunshine Act. You're not divested of jurisdiction just because we filed an appeal of the underlying conditions. You're still a party to litigation. You still have to act in your public capacity, which is what you're doing here tonight. The suggestion that you're somehow hamstrung in your ability to act as a public body simply because we filed an appeal is simply flat wrong. And if you need precedent to back it up, I will give your solicitor the citation to Smith v. Township of Richmond from the Pennsylvania Supreme Court of this year, 82-8-3-407, PA 2013, I apologize, 2013. You have authority to act here. And the suggestion to the contrary is flat out wrong.
The case that I believe counsel is citing, there's a distinction between a township or borough or municipality acting and the zoning hearing board act. The reason for that is how you sit as a quasi-judicial body, and also as once the action is taken, you technically, your decision stands, and it's the Common Pleas Court that is reviewing your decision. As you may remember, in the prior proceedings in this case, Mark West made the very same arguments, that the zoning board had no ability to go ahead and to appeal the decision of the Commonwealth Court because you were sitting as a quasi-judicial body and were therefore divested of jurisdiction to proceed in the action. The arguments that we're making is that once we intervene as a party and by filing our notice of mention in the Court of Common Pleas, that a settlement of the case has to be made with us as parties. And for the record, we have had no discussion, no reach out from Mark West as to settlement whatsoever. So it is our position, and we believe well supported and consistent with the position that Mark West previously took, that this board doesn't have the right to go ahead and unilaterally settle this evening without the input or participation of the parties.
Mr. David, maybe I'm missing something here. Can you explain to me what role the interveners have in this?
Sure. Under the municipality's planning code, once an appeal was taken, by which the appeal was taken from your decision by Mark West, any person who is directly affected by the decision has the right to file as of right what they call a notice of intervention. And that's a unique feature of the municipality's planning code that automatically grants party status to people who go ahead and file a notice of intervention. With some caveats, they had to have participated down below. They've had to, there are a couple items, all of which my clients meet in terms of that. Once that happens, you no longer have jurisdiction over the case. You are sitting as a quasi-judicial body. The jurisdiction is with the parties. It would be the same thing if we had taken an appeal of your decision. We couldn't go ahead and settle that case without Mark West if they had intervened, because they are a party in interest. They have an interest that will be affected by the settlement.
Mr. Augustine, this is a really nice speech, and Mr. Kamen can make it to the judge at the Court of Common Pleas in Washington County. You're a party. You have rights. You have the ability to act in furtherance of your own rights, irrespective of what these interveners think they can and cannot do. You're a part, just like I'm a part. Just because they are part of that litigation doesn't mean I can't talk to you. You are a party. You have rights, just like I have rights. Just like Mark West has rights in this case. If they have an issue with what you do here tonight, they can take it up with the judge.
I would ask counsel if that case that he cited is a zoning hearing board case.
Mr. Kamen, you can read it for yourself. It's right here. Go look it up. I'm not going to debate the finer points of the law with you tonight. You can go talk to the judge about it. If you think you have rights. You're trying to scare this board into not acting.
That's like the pot.
Excuse me, Jeff, I'll ask you, do we have a right to act?
I think there's a little more to it than has been brought up. I think they're both right in certain circumstances. I think there's one additional distinction that we have is that testimony was taken in 2011 and party status was established at that point. And that we took no testimony after the Commonwealth Court required us to grant a special exception application. So as to whether or not the interveners have party status, again, that will be up to the Court of Common Pleas. But they didn't appear in 2015 before the board because no one gave testimony this year. It would have been back to 2011, and I would have to review the transcript to see which parties actually participated at that point, but none of them participated in any of the litigation through the appellate courts.
So we do have an authority to enact a vote tonight, we do?
I believe you do, or you can table it if that's your decision. Again, this is a settlement proposal. It is not a requirement that you accept it or deny it in full. You could make a counteroffer, you could do nothing. So. The reason we're here is so you can discuss it in front of the public, so they can understand what's before us.
Well, I have a question. Would the interveners have an opportunity to meet privately with the zoning hearing board for fact-finding purposes?
Absolutely.
Well, I'm making that request.
Okay, we'll schedule something if that's what you want to do.
I want to make a motion that the stipulation of settlement presented by Mark West Liberty Stream, Midstreams and Resources LLC with regard to the pending land use appeal in the Court of Common Pleas of Washington County, that we deny that between Cecil Township and Mark West.
I'll second.
The motion being made and seconded, all in favor, vote by saying aye.
Aye.
All opposed? Nay. Motion carries.
I'll withdraw that request from the private meeting.
come before the board tonight? If not, I'll close the meeting. Okay, you want to speak, sir? Oh, let's go back one minute. Oh, you, I'm sorry, I didn't hear it.